The Honorable, the Supreme Court.
Morning, everybody. Thank you very much. Please be seated. And if you would call the case.
Good morning, Your Honors. The matter before the court this morning is entitled The State of Vermont versus Joshua McMahon, case number 23AP160. Representing the appellant Joshua McMahon is Alex Don. Seated at counsel table with Alex Don is Rebecca Turner. Representing the appellee, the state of Vermont, is Jared Bianchi.
Okay, thanks. Thanks again. Morning, counsel. If you would, please come on up to the podium. There's a button there that you can apparently raise and lower it depending on what you want.
Thank you, Your Honor.
No trap door. You've heard that already because you were sitting in the courtroom. I'm going to repeat it nevertheless. And so if you would introduce yourself and identify your client, then proceed.
Good morning, Your Honors. May it please the court. Alex Don, the Office of the Defender General for Appellant Josh McMahon.
Thank you.
Even when viewed in the light most favorable to the state, the evidence simply did not make out an intent to kill in this case. Before I discuss the video, which I will, just a quick reminder on what the state did not introduce in this case. There was no evidence whatsoever of any relationship between the assailant and the complainant. There was no evidence whatsoever of any motive for the assailant to intend or attempt to end the complainant's life. There was no serious injury to the complainant, although the complainant did receive a small scratch and a small burn. He was not seriously injured and did not request or receive any medical treatment at all. And finally, before I get to the video, since the complainant did not testify at trial, the trial record didn't even contain any evidence that the assailant had ever expressed an intent to kill the complainant, for example, during or slightly before the incident. None of that was there. The state's showing on the element of intent was entirely limited to what can be inferred from a 13-second silent video. And if the crime of conviction were merely assault, that video might well be a useful piece of evidence for the state. But Mr. McMahon is serving a sentence of 20 years to life in prison, appealing a conviction for attempted second-degree murder, and the video strongly supports the defense in this case because it simply does not support a reasonable inference beyond a reasonable doubt that the assailant had the intent to kill the complainant. And I'd like to focus on a few key parts of the video, but before I go any further, I just want to emphasize that while I've personally viewed the video a number of times, summarized it in our brief, what I'm about to say does not require this court to overturn or upend any findings that the trial court made regarding what can be seen on the video. And I'll explicitly refer to what the trial court found factually regarding what can be seen on the video. So the findings I'll be referring to when I discuss them are on the second full paragraph of page 3 of the printed case, where the court, in denying counsel's renewed motion for a judgment of acquittal, went thoroughly through the video discussing what can be seen and did not discuss an attempted slicing, did not discuss a purported stabbing, did not at any point in its own findings assert that what it, the trial court, could see in the video was the assailant ever attempting to stab, attempting to cut, or attempting to slice the complainant. And I'd just like to emphasize that the language the lower court used in its description of what can be seen in the video very, very pointedly and carefully went out of its way not to say any of those things. And I'll refer to 2 key points of the video first. At the very beginning of the video, at the very beginning of the incident that's caught on the footage, the assailant and the complainant come into the kitchen. And at the moment the video starts, the assailant is standing behind the complainant with a knife behind the complainant's throat. If at that point the trial court felt that the knife behind the throat was part of an active attempt to slice the throat, which my own viewings say that's not the case. But if the trial court thought that's what happened, the trial court would have said that. Instead, what the trial court said was, the man with the black helmet had the knife in his hand against the man's throat, but does not say that he was attempting to stab, cut, or slice him. The two men fall forward into the kitchen, even though the assailant is standing behind the complainant with his knife around his throat, and even though they fall forward with the assailant essentially landing on top of the complainant, the assailant manages not to cut, slice, or injure the complainant's neck at all. All of this is far more consistent with the suggestion that the assailant, who, yes, behaved violently, yes, behaved in a disturbing way, should not have done what he did, and probably behaved criminally, did not intend to kill the complainant. Now they're on the ground. No injuries whatsoever.
May I interrupt you there?
Of course, sir.
In your logic, it seems almost like you're saying we need to wait until he slashes the guy's throat before we can infer the intent. Is that what you're saying?
Your Honor, these are fact-specific inquiries, and I think the answer is, in this case, maybe. In a normal attempted murder case where there is more evidence of the surrounding incident, oh, these two men knew each other from the neighborhood, and they had a dispute over X, Y, or Z, and this is just, I'm sort of vouching in my own experience. One of them told the other guys he was going to get him. In a case like that, where you have more beyond the video, I don't necessarily think you would need something like what Your Honor just described.
Don't you have a witness who testified, one of the employees from the homeless shelter, who came in midway and testified that the assailant was trying to slit the throat of the victim?
Your Honor, thank you for the question. Yes, Chloe Collins did testify that, in her opinion, what she saw was the assailant attempting to slice the complainant's throat. But a few quick responses on that, very important. First, and most important, when Chloe Collins was asked on cross-examination, hey, look, essentially, you testified to this supposed slicing, but would you, Chloe Collins, agree that what can be seen on the video is what happened? She said yes. And I say that to say, I can certainly imagine a case where Your Honor's question would sort of be in the dagger in the heart of this case, because it's like, well, the person was standing, I apologize, the person was standing off camera. In this case, if Chloe Collins had said, I saw it from a different angle, right? If Chloe Collins had said, I saw this incident from an angle that was different from what the video camera captured, and I saw an attempted slicing, but the video didn't capture it, we would be in a completely different situation. In fact, what Chloe Collins said was, the video captures what happened. And then when we think, okay, well, what actually happened, we can look at, very quickly, we can look at what the state and the lower court said about that aspect of the case. Chloe Collins wasn't even talking about the very beginning of the case where the two men entered the kitchen. Chloe Collins, when she testified to the supposed attempted slicing, she was actually referring to the scuffle on the floor during which the assailant punches the complainant. Even the state, in their response to the defendant's renewed motion for a judgment of acquittal, didn't describe that part of the video as an attempted slicing or an attempted stabbing. What the state actually said when they responded to the renewed motion for a judgment of acquittal regarding that part of the incident is the defendant lost control of the knife for a minute before regaining control and proceeding to punch the victim repeatedly in the head. That's at page 32 of the printed case. So
How
Chloe,
important is it that there was a knife involved in this that clearly used by your client?
respectfully, Your Honor, it's a fact among many. Obviously, we would submit that the fact that a knife was involved has essentially no real bearing on its own of proving an intent to kill, because otherwise every knife possession case or every assault with a knife case would be an attempted murder. We need, it's a high bar, a specific intent to end the life of another human being. Mr. McMahon is doing 20 years to life because of this 13-second video, and with respect to Chloe Collins, really nothing else. People watch the video, it's a chaotic incident. It's violent. It's frightening. It's easy to look at the video and say, no one should ever do what this person did. But that is very, very different from saying, I can tell beyond a reasonable fact finder can tell beyond a reasonable doubt that the only thing that person could possibly have been trying to do was end that person's life when he leaves the complainant with literally a scratch.
So, you know, there's an old case, I don't remember the name of it, and maybe you'll know it, but and it's not a Vermont case, I don't think it's a Vermont case, but it's a case that talks about attempt to commit a crime, and in that instance, it had to do with the attempt of prisoners in jail to escape from jail. And when they found the prison, when they searched the cell of the prisoner, they found all the tools to dig a tunnel. And the fellow was charged with attempted escape. And the court said, no, you can't convict somebody for attempted escape because they have these tools hiding under their bed. So if this case involved your fellow with a knife in his pocket or the blade out, and it was not, but here we've got knife at the throat. You know, that's a lot different than having the tools under your bed.
I'd love to respond. Yes, knife at the throat. Well, what does knife at the throat with no cut really say? It says most practically, I'm trying to intimidate you, but I'm not trying to kill you. Because if I were trying to kill you, the knife wouldn't be at the throat. It would, like, sorry to be gaslit, it would be through the throat. There would be blood everywhere. This crime scene would have been a nightmare if the assailant had intended to end the life of the unarmed complainant. He was standing behind him with a knife to his throat.
Well, they weren't exactly standing. They were perambulating, you know?
They were in a standing position as they entered the kitchen. They fell forward, yes. But I having viewed the video a number of times, I will say there was a moment at the beginning of the video when the knife can clearly be seen, you know, at the complainant's throat, but not cutting it. And I would also urge the court to give deference to the trial court's findings. If the trial court thought that what could have been seen was an attempted slicing, the trial court would have said that. And I think we need to credit the trial court's decision not to say that. And
What about, how do we apply our standard of review here, which is very different?
I think that, I believe that, and MK is the case that discusses video evidence, but this court defers to the trial court's finding of facts, but considers questions of law de novo. So unless this court were to feel that the trial court had a clearly erroneous understanding of what happened in the video, this trial court.
Isn't it some evidence? There's some evidence to support the verdict.
There is, I would put it this way, there is insufficient evidence to establish beyond a reasonable doubt that this was an intent to kill. Was there enough evidence for a trier of fact to look at the evidence and say, I don't know, there's a chance that maybe he was trying to kill him, I don't know. Yes, but that's not the standard. It has to be a reasonable trier of fact beyond a reasonable doubt. No reasonable trier of fact could look at this video or read the trial court's findings and say that he couldn't have been trying to injure him or intimidate him, especially when he wasn't injured at all. I'd like to reserve the remainder.
Mr. Chief Justice, can I just?
Yeah.
Thank you. But this is framed as a judgment of acquittal.
Yes, Your
Does
Honor.
that make a difference?
My
Your
understanding,
standard?
my understanding, Your Honor, is that the standard is Rule 29 standard, whether or not, when in the light most favorable to the state and excluding modifying evidence, the evidence is sufficient to convince a reasonable trier of fact that the defendant is guilty beyond a reasonable doubt. I think that's the key part here, because there are so many other possibilities for what was going on here, and we just don't know because there wasn't enough evidence.
All right.
I hope I've preserved a little bit of time.
Yep, thanks very much. We'll hear from counsel for the appellee. Please come on up. And if you would, introduce yourself and identify your client for the record and then proceed.
Sorry.
That's it.
Your Honors, good morning. My name is Jarrett Bianchi. on behalf of the appellee in the state of Vermont, and may it please the court. This case and the arguments that you've heard are a really good example of why weighing the evidence that's submitted is the appropriate province of a jury and not the appellate process. With the appellate process being what it is, we're able to have a conversation about a very chaotic situation where it's presented in an almost procedural or linear fashion. What the record demonstrates, Your Honors, is that on April 22nd, 2022, the appellant sped onto the property of the local homeless shelter, ran after the victim, chased him up the stairs, and when a door slowed his flight, they crashed through that door with the appellant with a knife in his throat. Now, throughout this, you've heard arguments that almost seem to suggest that if the intent had been to murder that person, that the appellant would have succeeded. But that presupposes that the appellant was in sole control of that situation. What the record and what the video demonstrate is that he was not, that he continued his attempt to attack and to kill that person. We submit that both the witness testimony and the videos demonstrate that this was a directed, intentional attempt to kill a person by using a knife to slash their throat. And when the person was able to frustrate that first attempt, the appellant continued the attack.
So, Mr. Bianchi, it's your position that there was sufficient evidence for the jury to find beyond a reasonable doubt based on the facts that have been discussed here today to determine for conviction of the charge?
Yes, Your Honor. And we would suggest that here, where what you're hearing are two arguments about what is in the record, that the argument is not meeting what this court's standard has been, which is that there is not evidence on a particular necessary element. Here, 12 jurors viewed the evidence and came to a conclusion. This court has held repeatedly that when the jury enters a unanimous verdict, that it won't disturb it unless there is an absence of evidence. And here, what we're discussing is how somebody should weigh the evidence that is in record.
It is a curious case, is it not, that there's no context here, absolutely no context for what happened.
Your Honor, the record
So
is...
when you're looking at the jury, so the jury doesn't even have the complaining witness testify. They've got a video and they've got another witness, right?
There's more than one video that were admitted. And so the context that's necessary to the necessary elements of the case are all set forth. You do have that eyewitness testimony. You do have the videos of the person pulling in, chasing the victim, attacking the victim, and then finally leaving when others intervene.
And the case was charged how? One of the charges dropped out of the case. Why was that?
And Your Honor, I apologize, I was not trial counsel in this matter. I do believe that there was an aggravated assault count that did not proceed. But what the jury concluded was that there was sufficient evidence. And here we are talking about what that evidence is. In other words, I would point Your Honor to pages 150 through 156 of the January 11 transcript of this matter, where the trial court goes through painstakingly through each essential element after the state had presented its case and discusses what had been presented as to each element. Yes, the record is silent as to testimony from the victim, but neither party presented any actual evidence. And in our brief, we do discuss when an absent witness instruction is appropriate. And although that argument we submit was not preserved, we do address that in our brief, that it wasn't appropriate here because the arguments that they were seeking to make at closing were based on supposition.
What's the difference between aggravated assault and attempted?
Your Honor, with respect to an attempt to commit homicide, there has to be the specific intent to kill the person. Here, the video evidence of the person.
What about aggravated assault?
And Your Honor, there the intent can be a general intent to commit serious bodily injury, is my understanding of the case law. So here what we have, I'm sorry.
No, I'm just trying to, in my mind, trying to distinguish between those two crimes
Yes, Judge.
and,
And I'm sorry.
like aggravated assault without more evidence to show that there was an intent to kill.
Your Honor, this court has said repeatedly,
Otherwise, every aggravated assault becomes an intent to kill. So,
and I do think, Your Honor, that this is another important reason why the jury's role should be respected in this, because that's really a jury determination about what the state's evidence showed.
But you said the aggravated assault charge was dropped.
And Your Honor, I don't recall if it was dismissed or dropped as a lesser included.
I think it was elected by the state that it be dropped. There was a double jeopardy issue that was raised, and the prosecutor made the election to drop the aggravated assault.
after?
At trial?
And if I could just, I would like to respond to your initial question.
I believe that was when the judge was making her ruling on the judgment of acquittal.
And I believe it's in that same section of the transcript that we referred to. Thank you, Your Honor. The distinction between aggravated assault and attempted murder, as opposed to actually completing the murder where they weren't having intent, does need to be frequently inferred by the context of the action. And this court has repeatedly held two things: that intent is frequently inferred by the context, and here we saw the particular context on video and with live testimony, but we also saw something else this court has repeatedly said is incredibly probative to intent, and that's the use of deadly force. And here, where the person is attempting to use deadly force by using a knife to try to get at that person's vital areas in the throat, that is an attempt not just to
He was
use
at the
general
vital areas. He didn't attempt to get to the vital areas. He was at the vital areas with the knife to the throat.
That's right.
It wasn't like he's trying to get there. He was already there.
He was, in his attempt, he was trying to actually do the damage to those vital areas, Your Honor. And the video is in the record. You can see that although the person was successful in making his attempt unsuccessful, that the attempt was there to do the most serious, to actually kill by getting at that vital area. And in fact, when the defendant was able to fend off that first try, he stayed with the attack throughout the process until other people came in and he fled. So there is going to need to be, by any prior fact, some inference from those circumstances. But here where you have the execution, the attempt to use a deadly weapon in a necessarily vital area, even if it's not successful, even if the person is not in fact injured, that doesn't negate the attempt. So, Your Honor, the trial court does go through at length the evidence as to each essential element. We would point you to the pages of the transcript, especially at page 150 through 156. The appellant also raises several other arguments. We contend that they were not preserved, but we did address them in our brief. We rely on the brief for those points. And if there are no further questions.
Okay, thank you very much. How much time does the appellant have, please?
Appellant has 1 minute and 47 seconds left.
Counsel?
Your Honor, briefly, in response to the question regarding the aggravated assault count, just very quickly, what happened with the aggravated assault counts? There were actually 2 counts initially, one alleging aggravated assault in relation to the hot oil, another related to the knife. At some point during the prosecution, there was some back and forth. The state decided to proceed solely on the aggravated assault with the knife. That count was actually a count of conviction. The jury rendered a verdict of guilty. It was at sentencing on May 10th that the state on its own decided, for the double jeopardy reasons put forth by Justice Waples, to dismiss that count. Second, while I believe there are aggravated assault counts that do require a showing of serious physical injury, the count as charged to the jury in this case, because it involved use of a deadly weapon, at least according to the charge the court gave, required only proof of intent to cause physical injury, I believe, not serious, but that's sort of beside the point. The bigger point I just like to make, and you know, I could go in circles on this, and I don't want to, but I would submit, and my, the state just asserted that essentially he was trying to do damage to the vital areas, and I do think that's the important question, right? If we view the evidence in that way, it's hard. I don't have much of an argument to make but I would just suggest not only that, you know, the court and everyone watch the video, see what it says, slow it down as the court below clearly did, enabling it to write the statement of facts, which superseded my adversary was speaking about the trial court's oral findings after the motion to dismiss during the trial. But those findings, I believe, were superseded by the court's far more detailed, written, thorough findings that appear at page 3 of the printed case. Either way, when the court gave its written findings, it did not say, respectfully, it did not say he was trying to damage the vital area. I submit the court would have said that. The court is literally writing a decision affirming the denial of the motion to dismiss on the issue of intent in an attempted murder case. Clearly, if the court felt that it could see someone attempt to actually cut the throat, it would have said that. It's a startling omission, but not really, because when you look at the video, it is clear that while the man is holding the knife to the throat, there is no cutting action. There is no injury to the throat. There is no cut to the throat at all. And therefore, the trial court stopped short of saying that. This court should view the video on its own, but respect that determination
Thank you.
and hold that there simply wasn't enough.
Thanks.
Sorry,